Good afternoon. This is Jakelia Hooper from Yo. If you can listen, I'd ask that you put in your audio pin so that we can hear your dialogue as we engage in the conversation. And that's the number plus pound. Again, welcome to the call. We started the broadcast, but I just want to kind of reiterate that you received an audio pin. If you could hit pound, the number, then pound, then I can enable your audio. Hello? I see Christina and Kelly. Are you guys able to talk? Okay. All right, I see that you guys are both unmuted. Sorry, my screen is a little crazy. All right, so welcome to a continuation of the Yo Workforce Forum that we conducted in October. This is a follow-up to that as we ran out of time during the forum, and this was going to be one of the breakout sessions. And the title of this session is The Legal Landscape and How It Impacts Recruiting. Again, my name is Jakelia Hooper. I'm the Strategic Account Director here within Yo. I manage a number of our key customers and ensure operational excellence and program efficiencies. I'll just provide a really quick overview of what we'll be talking about. 3 key topics within the legal landscape today. Immigration reform, which is on everyone's, has been a discussion topic vastly across the industry. Paycheck fairness, which is rather new as of October, and ban the box. California passed some new legislation. Typically, once California does something, most folks fall in line. Are there any questions there? Awesome. At this time, I'd like to provide an opportunity for a brief introduction. I think I can start with Kelly. If you'd introduce yourself to the group, where you're at in your position.
Hi, can you hear me?
Yeah, I can hear you. Great.
Okay. So Kelly Meyer, I'm with Essilor, and I'm the senior talent acquisition recruiter and also manage the Yo MSP program based in Dallas, Texas.
Thank you.
Mm-hmm.
Shalia? Not here. Wellington? Christina.
Hi,
and go ahead.
This is Christina Howlett-Perez, Wellington Management Company. I'm a manager in the procurement organization in finance and administration, and I manage the MSP program for Wellington.
Awesome. And last but not least, Shalia? You may be muted.
Hello.
Oh, there you are.
Hello.
Hi, we can hear you.
Okay, good.
Can you introduce yourself, Shalia? Is that Shalia?
Excuse me?
Shalia, are you able to introduce yourself?
Hello, hi, I'm Shalia Gray from GE Appliances.
Awesome. All right, so I'll dig right in because I'm cognizant that we have a 30-minute window, and I want to be respectful of everyone's time. So the first topic is immigration reform, and I just want to give some context to it because it's been all over the news, and it's pretty helpful to kind of provide an overview. So, you know, the current administrative put in an executive order, Buy American, Hire American, and it kind of cascaded to a lot of changes and conversation. But what does it mean, right, as it relates to the workforce? Well, essentially, there are a significant amount of individuals within really the IT space and higher education that require H-1B visas. And the demand, as we all know, significantly exceeds the supply. So if you look at the first chart I have here in the middle of the page, you'll see that in 2017, there were 199,000 applications filed, and the cap's 85,000. The folks in red is a regular cap, and the folks in blue is an advanced cap, meaning they have an advanced degree, MBA, master's, PhD. And the cap was reached in April within 4 days. The chart below talks about the job titles and the average salary and the amount of applicants in each space. Keep in mind that number 5, computer programmer, is an entry-level role and will be eliminated on future H-1B applications. So we'll talk about that and what that means in detail on the next slide. On the on the right-hand side, it talks about the amount of workers that are here today. So if you look at it, entry-level programming coders make up about 8% of H-1B utilization. And then you find difficulty levels. And cyber and data security near the middle of the pack. It's the most difficult to find from an H-1B perspective, but I'm sure you guys know in your organization it's difficult to find in general, just because most organizations would tend to find or tend to gravitate towards individuals authorized to work in the United States, and they tend to be Americans just based off the security concerns. But you can see that there's kind of a big population here and how it impacts folks. If you look at the overall workforce, H-1B individuals and H-4 folks are individuals that are married to H-1B sponsors or visa holders. And it's about 2% of the workforce, right? So we're talking about right under 800,000 workers that this is talking through or applicable to. It doesn't seem like a lot, but it represents about $5.2 billion in staffing spend. Any questions here, just in the context of immigration and what's being addressed in our next slide? Awesome. Okay. So when we talk about immigration reform, it kind of goes in 3 buckets, right? The concerns. It has a bad rap, right? There's been negative media attention. There's 1,000,001 articles. There was a 60-minute special about, the reputation of these staffing firms or outsourcing organizations within the staffing industry, kind of flooding H-1B applications within the government. Offshoring and outsourcing has a restrictive H-1B environment. So when you look at kind of the reform and hire American, buy American, a lot of organizations that may have outsourcing or offshoring may either think about increasing that need, or firms that don't do it today may think about exploring that opportunity for the talent they need. The USCIS has increased enforcement, meaning, and I don't know if this has happened within your organizations, but there's been a lot of scrutiny now on the visa applications sent into the government, who's on them, where they're working. And what I've found, even at my customers that I manage, is that they may get a random call from the enforcement agency saying, hey, is such and such in your organization? And there's some digging that has to be done just because it could be going through a staffing firm. One of the extreme measures that folks are concerned about is that there's no H-1B in staffing at all. It's very unlikely, but it is a concern if you're unable to kind of tap into that talent base. And then there's always fear, uncertainty, and doubt. And there's a lot of restrictive talk and with executive order, and folks who just get concerned when that happens. So here, go ahead.
Oh, sorry. So I had a question. So
Sure.
We talk a little bit about fear, uncertainty, doubt, the anecdote, buy American, high American, but what are some of the changes and the restrictions? Have there been any actual restrictions or changes? I know that the quota is being met, but that's pretty consistent year over year, being met within 4 days. I know that there's been talk about being restrictive, but what have we seen come out of that? Anything, or are we just still
No, so it's still
talking
just
about
talk,
uncertainty?
right? Yeah, it's still talk. So when we go all the way to the right, and what does it all mean? The executive order can't change the laws on their own, right? It can change the execution of the existing laws, and that's why you see the increased enforcement, right? if you've read the news, there's been a number of agencies that have lied on their application, or you see firms, for instance, will call your organization. They could call Esler and say, there's been an application filed for someone within your engineering department, right? I'm just calling to confirm that this person is an employee and they're on site. And you're like, wait a minute, who are they? What are they doing, right? Because they may be through a third-party firm. So, one of the recommendations is, from a risk perspective, evaluating, right, in preparation, who you have working for you today through your third-party firms in general, right? Just so you understand who's on site and what kind of application status or visa status they're under. Just so that you're aware of who, what, where, why, when, should you get a call or a question. There's been no immediate change to the H-1B process, right, as a result of this. And, the market's just getting tighter and labor's getting tighter. What has changed is the computer programmer role will no longer be parcel for H-1B status. So that's the entry-level software developer, engineer is no longer going to be considered. So that may open up some additional opportunities for skilled labor, higher skilled labor in the H-1B category, but also may create a vacuum for your organization to review, how do we get entry-level programmers within the organization? How are we going to find the niche folks that maybe have 1 to 3 years of experience in this field that are on GitHub, that have development experience to kind of fill any gaps we have within our organization? Kelly, does that answer your question?
Yes, that's helpful. Thank you.
You're welcome. So
Hi,
again,
honey. What's up?
hello? I think I missed the conversation. So from an immigration perspective, I'll jump to the middle and the opportunities, right? The immigration reform limits Indian outsourcing companies, but it may create an opportunity for domestic IT staffing firms to kind of get into the market and increase their capabilities of bringing on talent. It will definitely, and I think we're seeing that in some of the key skill categories like BI or data analytics, there's increased competition. There's emerging technologies. Again, the AI, cybersecurity is really the hot space right now, and that's not necessarily areas that offshoring firms are focusing on. And then again, the computer programmer. So that being said, here's some questions I would throw out to you guys within your organizations to think about. Do you know the full extent of your exposure, right? Are you aware of who you have not only within your workforce that, may have visa status, but your contingent labor program? And take that one step further within your fixed price and SOW engagements. Do you know the full extent of of folks and who's on a visa and what your exposure is in the skill set categories? And one of the questions that I, think that creates, some game plan or contingency plan is, what happens if this population of workers went away tomorrow, right? Like, so do you know who they are and what would happen if they went away? Not to say that the current administration or the new viewpoint on Buy American, Hire American is going to impact you today. But if you think about kind of long-term worst-case scenario, how would you create business contingency plans to address that? And then again, creative pipelining. Computer programmers going away. So how are you going about getting new talent in or building a pipeline, right? So if you bring in individuals with that 1 to 3 years of experience, then they continue to stay. You kind of build and have a maturation of a pipeline of talent, specifically within the IT space. So my question to you guys are, what internal organizational trends are you seeing within your respective organizations specific to immigration reform and the ability to get highly skilled IT talent?
This is Wellington. I think that we're not really seeing changes yet. What we're seeing is more awareness. So to your point with evaluating who we have working today on site, who's on H-1B, understanding, where they work, where they sit, who they are. We're starting to do that, but I think we're aware that there could potentially be change. We're just not sure what does that mean.
Right.
And with the elimination of the computer programmer, entry level software developer, how does that, that's a broad job description. How does that parlay to our job descriptions for staff aug labor?
Yeah,
and
so from
contingent
that's a great question. So from a staff aug perspective, fixed price, some organizations don't require individuals to list the actual person that's doing the work, right? So if you have an outsourcing or deliverable-based organization working for you, they may just have an SOW that says this is what we're going to deliver. Some measures you can put in place is who's working on that, right? Just to kind of build that pipeline of awareness. And typically the computer programmer is your entry-level programmer. So the questions that you would ask these individuals that are supplying are like, how many years of experience do they have? What are they doing? And typically they're developers, software engineers in that 1 to 3 years of space. Okay, so I'll move to Paycheck Fairness Act. This is a new bill that aims to remedy pay disparities for women and minorities. It was signed in November 2016, and it bans salary history inquiries for government employees, but it's now going out to the states. And basically what is happening is it's prohibiting private employers, from inquiring about a job applicant's salary history at any stage of the selection process. So this includes full compensation, salary, benefits, and other forms. In Philadelphia, that was the first city to pass it, but it's currently in litigation. And as you can see here, New York's passed in October, Delaware in December, California, January 1, and Massachusetts in July of next year. But there's also other states in consideration: Illinois, New Jersey, Maine, Maryland, Rhode Island, and Vermont. And essentially what it's trying to do is address pay inequities. So if you look at this chart here, it shows that minorities and women make less historically than men, and it's trying to eliminate these kind of decisions that could have been or could be discriminatory. So what's the impact to your organization? Revisit your recruitment process, including your applications. Are you asking individuals if they have what their previous salary history was that may need to be modified if it's applicable in your state? But know that once a couple states sign on, it could very well have broad sweeping implications. Retrain your hiring personnel to, when they're interviewing individuals, to be cognizant to not ask what you were making, what was your last salary, right? If an individual voluntarily provides the information, that's great. But you may very well need to have a documentation process in place to, prove at any given point that the person gave the information up voluntarily. And then prepare for compliance, right? Documentation and recording the information shared. Evaluate and benchmark your salary, your salary for all your positions, and explore adding it to your postings. So if you go on Indeed today, or if you go on your own website with your careers page, chances are you don't have the salary information on there. And now would be probably a good time to look at your skill categories, your titles, and benchmark that. So you can use TDX Exchange, Career Builder, Wanta Analytics. You can go to your Yo folks and say, hey, help me benchmark my salary for these positions. And you can do it by geography. You can do it by years of experience. And then have salary ranges ready should the legislation come to your respective areas, so that you could post it with the position. And then ensure your supplier partners are doing the same. So very often I've seen my clients, if they push forth some new policies and procedure, they'll come to Yo and say, we want you to enact this policy and procedure as well. And that way we're mirroring the processes that you have in place to ensure compliance. So the questions I have for the collective group is, when was the last time your organization benchmarked or cataloged your positions? Anyone?
No idea.
Right. And what goes into formulating your new hire compensation, right? Typically you have a salary range, and that's the range, and you know that's been the range. But when was the last time you actually kind of took a look at and said, okay, let's start from our entry level all the way up to our most senior? Have we evaluated that compensation package? And then the third question to think about within your organization is, if you're a multi-state employer, how do you enact a uniform policy? As the states, you know, there are some states where there's a rule and there's a law, and then there's some states that could be forthcoming. So just some things to think about.
So this makes sense for full-time employees. How do we equate this to contingent workers? Is this applicable to contingent populations? So such as, you know, we're looking to hire for an hourly wage of $25 an hour for this temporary resource. Typically, we will ask, what were you making in the last position? Does it fit within the grade? Sometimes we like to understand insight into markups and pay rates. What does that mean for contingent?
Great question. So as an employer, Yo is an employer, right? And we supply contingent workers. The Paycheck Fairness Act would be applicable to Yo. So we would have restrictions on what we ask from a pay rate perspective. But to a customer, if you have a markup-driven account, a markup is a markup, right? So the salary rate, the pay rate wouldn't be as instrumental in your relationship with the staffing firm if you have a markup-driven. But from a Yo perspective, but from a Yo perspective, we're already starting internal trainings with our recruiting population to say, you can't ask the question, what did you make? Right? You know, and providing protocols to document if that information has been provided voluntarily. And ideally, we have to change the way that we're recruiting and talking to candidates, because we could be held liable as well. So, you know, what we're saying to individuals is, this position pays between X, Y, and Z, right? Is this something you would be interested in? Now, mind you, it's new. So it's still kind of, go ahead.
I was going to say that, you know, when this law first got rolled out for January for us at my organization, I mean, we started the philosophy to all of our recruiters to ask, what are your salary expectations? And starting with that information as opposed to even going into their salary history.
But what if we have our current contingent workforce on site, and obviously they're not employees of ours, they're employees of yours, and we want to know, what are they making? What is the markup? We don't have a markup model, but every once in a while we like to understand what the population looks like. So what is the pay rate that you're making now? Is that something you think we would still be able to ask current state?
Great question. I'm going to have to come back to you on that one.
Okay.
Just because I don't want to give the wrong answer, but I'll make sure that I follow up and get you the right one. These are individuals on site right now that are employed through Yo, and if there's interest in them, you want to you want to see if you're able to ask what their existing pay rate is.
Yeah. Sometimes they look at that for conversions. Sometimes they just want to know if the markup model still makes sense, or the non-markup model still makes sense, by understanding how large our markups may be or not.
Got it. Okay. Yeah. Let me get you some specifics there. I have my own professional inclination there, but I want to just confirm it, and then I'll follow up with the collective group. You're welcome. Any other questions there? Good dialogue. I know for me personally, I have to think about different ways in which, you know, you talk to individuals. And to your point, Shalia, what are your salary expectations is a good first step. Okay, last but not least, and we have 4 minutes left, so thank you for your time. ban the box. So essentially, California, again, is leading with net new regulations. And essentially here is ban the box is not new. It started some years ago where it's saying, you know, if you have on your employment application a box saying you've ever been convicted, arrested, et cetera, that of anything, please check this box. And that has been banned in a number of states just because it felt like it was discriminatory in being able to hire individuals. So this is taking this step one step further and providing a fair chance policy. So currently there's 226 million people living in a jurisdiction with some form of ban the box. And ideally, and statistics are saying that 1 out of 4 Americans have a criminal record. So in October, there's a California Assembly bill. It's called Bill 1008, AB 1008. It is a new statewide restriction, and it restricts an employer's ability to make a pre-hire or personnel decision based off an individual's criminal history. And it's effective January 1. So things that are the same or would be similar would be, you know, you can't necessarily, it makes it unlawful to include an application for employment any question that seeks a disclosure of the applicant's conviction history. That's the former ban the box. That's pretty wide-reaching and known. Additionally, you can't necessarily do any inquiries on an applicant's previous conviction history before the applicant receives an offer. But where this 1008 bill kind of goes is it says that now if the person does come back with an adverse criminal conviction, you have to take it one step further and consider, distribute, and really evaluate the information on the conviction history and allow that individual to dispute it. So you can't just do a broad sweeping, they don't pass our standards and we won't hire them. Any questions there? Okay. So how does it work, right? So as an employer, if you offer someone employment and then after they kind of they accept it or to do like a verbal offer, you can send them another application that asks for like the background screening, et cetera, et cetera. That's still legal. But what happens is if something adverse comes back, you can't just outright decline them. You have to be able to look at what they've done, the offense they've done, and the conduct, the time that's passed since it happened, and the sentence that was handed out, and the nature of the job that the person is seeking. You have 5 days to notify them in writing, inclusive of why you're making the decision, what led to the decision, et cetera, et cetera. And what happens is they have 5 days to provide you a decision on whether they will respond before you can make a final determination to revoke their employment offer. In that 5 days, they can look at the submission of evidence, they can challenge the conviction history, they can provide you a history of their rehabilitation or the mitigating circumstances that applied to this conviction. And then after that, they have an additional 5 days to gather any data that they need. So there's a potential 10 days from when you've made an offer to when you can kind of make a final determination. Should you decide to not hire the person based off of all the information presented, you have to then give them a formal decision in writing. You have to provide them of the appellate procedure. They can go with the Fair Credit Standard Act. They can dispute it with the legal entities in California. And then you have to notify them of the right to file a complaint. Employers are concerned about this, right? They're concerned that this provides an opportunity for an applicant to say, I was not hired because of my criminal conviction, and kind of lead them to the steps of the courthouse. But California, took all of these complaints and concerns in stride and still passed this. So this is effective January 1. So this just is food for thought. I don't necessarily know how much or how many other states are kind of reviewing this. But again, it's an opportunity to review your application and hiring process, understand an assessment, and understand the assessment that California is asking for employers to provide to candidates, and then create documentation methodologies to ensure that you are covering your bases applicable to the law. This is just food for thought. I don't know if you guys have employees, I'm sure you do, in California, and if you've already started kind of reviewing this. Shalia, GE is huge. Have you heard of this legislation? Are you on top of it already? No? Okay. All right. So I'm butting up against 1 o'clock. It's 1:02. Are there any other questions? Is there just the 3 topics I wanted to talk through today?
None from Christina at Wellington, and I do need to jump off. Thank
No
you very
worries.
much. This was helpful.
Thank you. And I will send a follow-up to answer any additional questions you had. Thank you guys for your time. Bye-bye.